All right, well, good afternoon. Welcome to this public forum organized by the Jack and May Nathanson Center on Transnational Human Rights Crime and Security, focusing on torture and aiming to take stock of the state of play and of official attitudes towards this cruel and inhumane practice here in Canada. My name is François Tanguay-Renaud, and I'm actually the director of the Nathanson Center, in addition to being a professor here at Osgoode. And this is not the first public forum held here by the Nathanson Center. And unfortunately, it's not the first public forum focusing on the question of torture and Canadian officials' attitudes towards the practice. In the winter of 2007, the Center organized a series of public events, critically examining issues, including the question of torture, that were raised by the experience of McElroy at the hands of Canadian, American, and Syrian state authorities. And again, in February 2010, we held a large public forum like this one, in fact, it was even larger, to address the still unresolved issue of alleged transfer of Afghan detainees by Canadian troops to Afghan authorities with the knowledge that they would be subjected to torture. Now, at the time, recall, the Conservative government had gone so far as to prorogue Parliament to thwart democratic accountability processes aimed at this issue. Now, arguably since then, things haven't gotten much better. In fact, it's possible that they've gotten much worse. And the prime impetus for holding this forum today, at this time, is the sheer amount of ominous news items that have come out of Canada in recent months, in fact, let alone years, with torture or complicity in torture in the headline. Indeed, earlier this year, the Canadian media reported that the Canadian government had actually expected, as evidenced by correspondence obtained by journalists, to face grilling by the United Nations Committee Against Torture, which is in charge of monitoring the implementation of the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment to which Canada is a party. And the committee's report, if you read it, which was released last June, makes it quite clear why there was such an expectation. And why was that? Well, the committee expresses serious concerns about Canada's actual compliance with the Convention Against Torture. And here are some salient examples. Right, in relation to the ill-treatment and torture of Canadians detained abroad, the committee condemns Canadian officials' actual complicity in the human rights violations of now infamous Omar Khadr while he was detained in Guantanamo, and the delay in approving his request to be transferred to serve the rest of his sentence in Canada, following, you'll recall, our Supreme Court's failure to order his transfer back as a remedy for his charter rights violations. The committee also expresses serious concerns at Canada's refusal to offer an official apology and compensation to the 3 Canadians, Mr. Al-Malki, Al-Mati, and Nureddin, who were tortured in Syria, partly due to lapses by Canadian agencies. And that despite the findings of the Iacobucci inquiry to the effect that such remediation should be forthcoming, and despite lessons from the highly mediatized Arar inquiry. Now, as noted earlier, and I think it can be said as a result of political maneuvering, the question of knowledge by Canadian officials that detainees transferred into Afghan custody might be tortured remains without a definitive answer. And here the committee also voices concerns about several additional reports of prisoners transferred by Canadian forces in Afghanistan into the custody of other countries who have actually also experienced torture. Serious concern is also expressed about the ministerial direction to the Canadian Security Intelligence Service, that is CSIS, directive which has now been extended to the RCMP and the Canadian Border Services Agency, and which allows intelligence information that may have been derived through mistreatment, including torture, by foreign states, to be used within Canada. In some cases, the directives also allows for the sharing of information with foreign states, foreign agencies, even when doing so poses a serious risk of torture. Now, these directives, the committee points out, could well give rise to violations of at least 4 central articles of the Convention Against Torture. Now, coupled with the lack of information about measures taken by the Canadian government to establish a system for the comprehensive review and oversight of security and law enforcement agencies involved in national securities, as may be noted was recommended by the Arar Commission, while these directives are certainly quite worrying. The committee also goes to considerable lengths to outline the various provisions in the Canadian Immigration and Refugee Protection Acts, the new euphemistically called Protecting Canada's Immigration System Act, as well as constitutional case law, including the Suresh exception and government practices of diplomatic assurances that allow for the deportation, or in more technical terms, for the refoulement to other countries of individuals who may face significant risks of tortures there. The committee also discusses the security certificate system as put in place following the Shirkawi decision of the Supreme Court, and it finds that the role of special advocates, which it creates to handle sensitive evidence, which is classified for reasons of national security, is too constrained to allow the special advocates, to know properly the case that they face, and sometimes the origin of some of the evidence, and thus sometimes prevents them from making full answer and defense. And what about civil cases, the committee remarks, where there's a patent lack of effective measures to provide redress, including compensation to victims of torture. And for those who may think that none of these issues relate to torture at the direct hands of Canadian officials, over and beyond complicity, which, to be clear, in many people's view, and in fact, including the view of the law, is no less problematic, the committee makes sure to point out, for example, the lack of binding guidelines establishing a consistent and sufficiently high threshold to govern the use of conducted energy weapons, or tasers, across the country. And here we have several heavily mediatized examples of abuse at the hands of authorities, sometimes having resulted in severely painful deaths. The committee also expresses concern at the official use of solitary confinement in the forms of disciplinary and administrative segregation, often extensively prolonged, even for persons with mental illness. And although the committee's report is silent about specific cases, beyond noting certain inadequacy in the infrastructure of our detention facilities and incidents of in-custody deaths, one can also think of cases like the case of Ashley Smith, the teenager who, while in custody, was duct taped and drugged against her will by guards, leading to her death by choking. Of course, there's no denying that in November, our Prime Minister came out and publicly criticized the authorities on their handling of Ms. Smith's case. But as the opposition was quick to point out, these prime ministerial criticisms only came after the government spent years trying to conceal from public view the video footage that exposed the affair. So it should perhaps come as no surprise that Canada submitted its reply to the questions of the Committee Against Torture a mere 3 years after they were supposed to do so, and that some high-rank Canadian officials chastised the committee as just another committee and just another site of undue UN bureaucracy. Now, this is torture that we're talking about. But let me stop here. I hope I've said enough, at least to persuade you, that Canada is at an important juncture with respect to its stance on the practice of torture, and that now is a timely moment to take stock of where we're at, and to do so in the context of a public forum. I note that this event is being recorded and will be broadcasted on YouTube in the coming days. Now, to address this issue of momentous importance, we have assembled an impressive lineup of experts, including many leading advocates, Canadian and American academics, former highly ranked civil servants, journalists, parliamentarians, who have spent many years of their lives thinking seriously about the practice of torture, the multifaceted issues that it brings forward, often directly confronting the practice in their own work. Unfortunately, no currently sitting civil servant or elected representative from the Canadian government, and by government I exclude obviously Her Majesty's opposition, since we have a representative today. So none of them have agreed or been able to join us today to give us their viewpoints, despite our numerous invitations. So their actions and their policies are really what we have to go on today. I'd like to take this opportunity briefly to thank all the panelists, to thank all the chairs for their enthusiastic response to our invitation, and especially Ron Atke and Anil Kapoor, who in some of their incarnations are external research associates of the Nathanson Center, as well as Craig Scott, who's the former director of the center, for their generous assistance. So the forum will be subdivided in 3 1-hour and approximately 40-minute panels, each separated by 10-minute tea and coffee breaks. The first panel will focus on evidence of torture in Canadian courts, the second one on evidence of torture and executive action, and finally, evidence of torture and in armed conflicts. Each panel will adopt the same format. There'll be an introduction by the chair, and then each panelist will make a short presentation outlining issues and concerns that they think are most relevant to the topic of their panel. And then the chair will open the discussion, inviting panelists to react to each other, as well as inviting the audience to chime in and to ask questions to the panelists and to intervene. So if you want to ask questions after the presentations, there are 2 microphones. We would ask you to line up behind them and to wait until you're called upon by the chair to make your interventions. Chairs have been instructed to try to keep us to time. We have a tight schedule. So I would ask you to do, or at least help us, do the same by keeping your interventions short and to the point, so that as many people present here can participate, because I'm sure there are a lot of people who are eager to contribute. I would also ask you to try to be back in the room for the beginning of each panel so that we're able to keep the schedule on track. So without further ado, I'd like to turn it over to Professor Ben Berger from Osgoode Hall Law School. But before that, I would like to thank you very much for showing concern and for being here today. Thank you.
Welcome, everyone. I'm Benjamin Berger. I'm a professor here at Osgoode Hall Law School, and I'm delighted that you've been able to come to both the forum as a whole and to this panel, which has, as you can see, a number of august representatives from a variety of different dimensions touching upon the issues that we'll be discussing today. This panel is about evidence of torture in the courts, immigration context, civil and criminal context. And as we move through the remarks that constitute the first part of this section of today's forum, we're going to be moving with James Stribopoulos through a discussion of torture and domestic criminal investigations, talking a little bit about legal remedies in our courts. Tara McElroy will take us through some particular cases, 2 cases in particular, that will give us some particular focus for our reflections and comments, both cases that have to do with the authorities using information derived from countries with poor human rights records. After which, Barbara Jackman will be pushing us a little on our concept of what constitutes torture, how do we think about responsibility and determine responsibility. And then Anil Kapoor will be rounding out the comments that are the first half of the session, speaking a little bit about this complicated relationship between intelligence norms on the one hand and the legal system on the other. And so we have a lot to look forward to, and we begin with Professor James Stribopoulos, who's the Associate Dean here at Osgoode Hall Law School, an expert in criminal law, the law of evidence. James, please.
Thanks very much, Ben. And thanks very much, François, for organizing this important event and for inviting me to participate. So I've been tasked with talking about torture in the context of domestic criminal proceedings. And I suspect for many of you, the very notion that this issue would arise in domestic criminal proceedings seems a bit surprising. In fact, I think the popular conception amongst Canadians would be that torture is something that's perpetrated by foreign representatives in distant places, that to the extent that we're complicit in it, it's by turning a blind eye to that reality and taking advantage from time to time of some of the fruits of it. But sadly, I am here to report that if you pay close attention to what happens in our domestic criminal courts, you will see from time to time evidence emerge that the practice of torture is something that occasionally and sadly is also a domestic reality. I want to start because, I mean, one of the difficult things when it comes to torture is, as we've seen with the recent experience in the United States and the semantic debates over what is included and what is not. Enhanced interrogation techniques, we're told, are not torture. And I just want to clear the air in terms of matters on a domestic front, because we have a relatively clear domestic definition of torture. And you might be surprised by that. There's actually a provision in our criminal code, almost never charged. In fact, I couldn't find a case in my very brief research where it has been, and I can't remember one where it has been, frankly, but it's there. Section 269.1 of the Criminal Code makes it an offense for any official or person acting at the instigation of an official to consent or to inflict torture on any other person. And if you do that, you're guilty of an indictable offense. It's a very serious one. You're liable to imprisonment for up to 14 years. Officials defined rather broadly to include, not surprisingly, a police officer, I should say a peace officer, a public officer, a member of the Canadian Forces, and essentially any one of those officials or someone acting in a similar capacity abroad. The key thing here is the definition of torture, which the Act gives us, which the Code gives us as provision. We're told that torture means any act or omission by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person. A, for a purpose including obtaining from the person or from a third person information or a statement. Sub 2, punishing the person for an act that the person or a third person has committed or is suspected of having committed. And sub Roman 3, intimidating or coercing the person or a third person. And sub B defines torture as doing any one of those things, intentional infliction of suffering, pain or suffering, physical or mental, for any reason based on discrimination of any kind. And it's no defense under the provision to claim adherence to an order of a superior. So we have this pretty robust, clear domestic definition of what constitutes torture. And as you can see, if you physically assault a suspect in custody in order to obtain a confession, or because they've exhibited an attitude that you take exception to in the course of your official dealings with them, and you decide to mete out some street justice by using force to harm them, to injure them, that qualifies as torture. So circumstances in which we have the police on occasion in Canada using gratuitous violence and effecting an arrest, punitive violence in the aftermath of a high-speed chase, sometimes captured on video, or using violence to coerce a confession. They don't happen very often, to be sure, but they do, those circumstances do arise from time to time. They're never charged as torture, of course, to the extent that they're charged, and they aren't that frequently, for all sorts of reasons that you're well acquainted with in terms of proof and the challenges of proof. But when they are charged, they're almost always charged as assault or assault causing bodily harm, but never torture. So there is a phenomena that does exist of the police engaging in these sorts of practices. It's never labeled as torture, never prosecuted as such. So in the courts, of course, let's say the police have used excessive force in an effort to obtain a confession. We're all accustomed to the use of the rules of evidence and familiar with the notion of the rules of evidence being used to exclude coerced statements. Long established rules of voluntariness require that a statement obtained through threats or through violence must be excluded because it's involuntary. There was, no doubt, a time in our history and in the history of the United States where the third degree, as it was known, was quite common. These sorts of methods, because they're so crude and frankly ineffective at yielding reliable information, have been overtaken by methods that are coercive but much more psychologically coercive than physically. So the read technique is something you might be familiar with, and it plays on the sense of isolation and vulnerability that most criminal suspects feel when they're isolated and alone in police custody and being interrogated. But from time to time, cases have arisen where violence is used. A couple of years ago, right here in Ontario, in a case called Tran, the Ontario Court of Appeal was dealing with a case where Mr. Tran, who had been wanted and arrested for a string of home invasions, very serious crimes, brutal violence used by the perpetrators, and he was supposedly the kingpin. The police wanted a confession, and soon after taking him into custody, they made it known to him that if he didn't provide one, things were going to go hard for him. Well, he insisted on asserting his right to silence and his right to counsel, and that assertion was met, according to the record, which was confirmed by the Court of Appeal and findings of the trial judge, with a blow to the face and a number of other blows to his ribs when he was taken to the ground in the interrogation room, and essentially had a beating visited upon him. His jaw was broken. And at trial, the trial judge was met with an application to stay the proceedings. Of course, any confession obtained in those circumstances, if he can make it out, which he managed to, would be excluded as involuntary. But is that enough? I mean, they still had him dead to rights with the remainder of the evidence. Is there something so offensive about how the police had conducted themselves in this investigation that the state should be foreclosed from going forward? And the trial judge said no. It's too bad. They did violate Section 7, his right to be secure in his person, in a way that was not in accord with the principles of fundamental justice. They violated his right not to be subject to cruel or unusual treatment or punishment. But the remedy was a discount in his sentence of about 50%. And that's it. It went to the Court of Appeal. Issue was that appropriate? Should more have been done? And a fair amount of hand-wringing on the part of the court. And in concluding that a stay was warranted and that a 50% sentencing discount wasn't enough, they pointed to not just the beating, which they emphasized as being a very significant and gross violation of his rights and a huge breach of trust, but they also pointed to the fact that the police officers had tried to cover it up, essentially by denying it, cleaning up the blood, and then testifying that it hadn't happened in court. And then the fact that after the trial judge had found that it was something that took place, that the police officers still sat in the courtroom and effectively participated in the prosecution, which the Court of Appeal took exception to as being entirely inappropriate in the circumstances. And for that collection of reasons, the court, in a rather unprecedented decision, stayed the proceedings on appeal. It was big news. You might remember the case. And you think the message that would come out of Tran is, if you engage in torture, police, all bets are off. The benefits of your investigative efforts that didn't involve such objectionable techniques will be for naught. The case will be tossed, barring other exceptional circumstances, like you're dealing with some extraordinarily serious, I can't imagine them staying the prosecution against a Picton character, but short of that. And yet last summer, there was a case involving the Toronto hold-up squad, a case in which a fellow was taken into custody, pretty ironclad case against him. It was a robbery from a commercial premises that he happened to be an employee of. And the police had him dead to rights, but they wanted to know who else was involved. And over the period, and this was the subject matter of findings on the part of the trial judge in this case, here in Toronto, over the period of an hour and a half, on 3 separate occasions, 2 police detectives went into the interrogation room and essentially beat the fellow up, repeatedly. They wanted him to name names, and he wasn't about to. He was asserting his right to silence, his constitutional right. They let him stew about it, and successively, over 3 separate periods, came back and beat him up again. Blows to the head, to the back of the head, a knee to the chest, taken to the ground, really roughed him up. They brought his co-accused, who had also been roughed up and had his rib broken, to take a look at him, and so they could see one another to know that they were both caught. And the co-accused in his testimony described this accused as looking like he had just been in a fight. The findings were clear. The evidence of the accused, for whatever reason, went uncontradicted. The police did not testify. The trial judge made those findings. Over an hour and a half, 2 police officers, Toronto Police Force, beat this individual up on 3 separate occasions in a sustained and deliberate way to obtain a confession and to obtain information. He was convicted following a trial on the facts, and he brought a stay application based on this misconduct, seeking what Tran obtained, which was a stay of proceedings. After full argument, the trial judge said it's terrible what the police did, but these crimes are serious. It was an armed robbery. And the discount that was awarded in terms of the sentence that was given was essentially this. She said, This fellow who had no prior criminal record would ordinarily have received 65 months in custody for this offense. In light of the egregious state misconduct, which I find abhorrent and really reprehensible, I'm going to give him a discount of 12 months. And so his sentence was reduced from 65 months to 55 months. I personally find that shocking. And I'm not sure if you do. I didn't hear any gasps in the room, so maybe it's just me. I know it was a dinner party. Oh, okay, good. I'm glad to hear that, Barb. I was at a dinner party the other night talking about this case, which I'm actually counsel on. I'm trying to get the Court of Appeal to rethink what the trial judge did in this circumstance. And I mentioned this to someone, a law-abiding, upstanding professional, not a lawyer, the scenario just described. And he said, well, is the guy guilty? And I said, well, the Crown had a pretty strong case, to be sure. He says, so what? And I fear, so what in the sense of, big deal. If the guy's guilty, what's wrong with the police tuning him up a bit? And I do really fear that maybe that sentiment expressed by that fellow at the dinner party is more dominant than I like to believe. I'm a law professor. I operate in the ossified sort of world of legal academics, where we take constitutional guarantees and human rights quite seriously. So maybe I'm overly sensitive. But I'd like to think that facts like those I just described to you would be shocking to most Canadians. And I think one of the culprits here, frankly, in terms of why a trial judge like the one I just described was reluctant to order a stay, is sadly our Supreme Court of Canada, which has sent a very clear message to lower court judges that stays are very, very, very exceptional remedies, not to be granted too readily. And if you can still have a fair trial on the merits, right, so that whatever the state's done hasn't undermined the right to make full answer in defense, especially in a serious case, you should guard against using the blunt instrument of a stay. And that's the message that's gone on down to trial judges, although if you read the Supreme Court jurisprudence very carefully, which I'm going to try to get the Court of Appeal to do in this case, I think that's wrong. The Supreme Court actually left some room to maneuver for really, really egregious violations of individual rights. And the case in which that I'm referring to is a case called Tobias. And the Supreme Court actually said in Tobias that if the authorities were to fabricate and plant evidence at the scene of a crime, the continued pursuit of the criminal prosecution might well be damaging to the integrity of the judicial system and warrant a stay. And I'd like to think that this is far worse than just planting evidence. This is trying to manufacture false evidence through violence. And if anything warrants a stay, that should. Anyway, I'll stop there. My time's up.
Thank you, James. Well, thanks very much, James. And moving from the domestic criminal context, Tara McElroy is going to be speaking a little bit about some cases that involve additional contexts in which evidence of torture has arisen. Tara is a graduate of the University of Toronto, works at Waldman and Associates in immigration, refugee law, and we're delighted that you're here, Tara. Thank you.
Thank you. So I think some of you may have been expecting Lorne Waldman. I, as you may notice, have a bit more hair, but substantially less wisdom and expertise. So thank you for having me regardless, and Mr. Waldman, Lorne does send his regrets. What I'm going to do is sort of in light of how the forum was described on the poster, taking stock. I think the two cases that I'm going to describe help us to take stock of what's going on recently. They're cases where Canadian officials have put forward evidence in immigration proceedings against clients of our firm where the evidence came from a country with poor human rights records. The first case is a Canadian permanent resident who is subject to an Interpol red notice initiated by a Central Asian country with a poor human rights record. Last January, a CBSA officer issued two Section 44.1 reports, which mean that the officer is of the opinion that our client was inadmissible based on alleged white-collar crime committed abroad. A different officer issued a direction for an admissibility hearing, and a third officer issued a warrant for arrest. Our client was arrested and detained, and we subsequently challenged these four actions as decisions under 4 applications for leave and judicial review at the federal court. We've had numerous motions before the federal court on this matter, including to obtain the tribunal record ahead of the normal schedule, which we've been successful in, and additional disclosure, which has helped us to establish some of our case. Based on the disclosure we've received, it became apparent that the officers involved in the case, through numerous sort of channels with RCMP liaison officers and other officers abroad, Canadian officials, they'd received information from the authorities abroad, the authorities in this other country, which included court documents against our client, and that they had not turned their minds to the possibility that this information may have been obtained through torture. We learned that a Canadian official had met with the security apparatus in this foreign country, and that some information had gone back and forth, not just one direction from this foreign country to Canadian officials, but the other way as well. This country has been criticized by human rights organizations such as Human Rights Watch and Amnesty International. Amnesty said that reports of torture and other ill treatment by security forces continued unabated in recent years. This is a recent report, despite government claims that it was successful in addressing these violations. The United States Department of State, which is widely considered to be reputable by both sides, has identified corruption of the judiciary as a particular problem. Domestic and international human rights organizations, the US DOS tells us, reported numerous problems in the judicial system, including lack of access to court proceedings, lack of access to government-held evidence, frequent procedural violations, poor explanation of rights to defendants, denial of defense counsel motions, and failure of judges to investigate allegations that authorities extracted confessions through torture or duress. Pursuant to some of the federal court proceedings under cross-examination, one of the CBSA liaison officers who had been involved in the sharing of information and the receipt of information in coordination with a RCMP liaison officer, the CBSA officer admitted that he himself was not aware of any concerns in relation to the human rights situation in this country. He became aware that our client had asserted that the prosecution against him in this country was politically motivated and that evidence against him had been obtained under torture. But this official took no further steps to consider these assertions and was not instructed to make further inquiries as to whether or not there was a risk that information sharing could lead to torture. We actually found out as well that officials had requested information from non-human sources when they realized that counsel was asserting that there may be evidence obtained under torture in order to sort of get around the argument. This officer admitted that he had never considered the country conditions in this country prior to disclosing information from Canadian officials to the officials in the other country. And he was unaware that the Department of Foreign Affairs and International Trade published annual human rights reports regarding these countries, regarding various countries, including this country. He himself had not reviewed this report, obviously. He considered himself a conduit of information sharing. So of particular concern to us in this case, an associate of our client who also has a criminal proceeding in this country was arrested, and there have been public reports of allegations of torture of this associate and an affiliate of his. So we have argued that it's part of other things that have been going on in the case, but we've argued that there's an abusive process resulting from this conduct as well as other conduct, and that there's willful blindness being demonstrated on the part of the Canadian officials. We have been successful on some of our motions before the federal court, particularly we did establish an error of reality to the abusive process, although that may have been connected with another argument more than the possibility of torture argument, but we have established an error of reality. We did get the early production of the tribunal record and some advanced disclosure, as I mentioned, and an interim stay of the admissibility proceedings. The court does appear to take seriously the possibility that Canadian officials in this case may have failed to consider whether evidence provided to them by international counterparts may have been obtained under torture, which is promising, but we'll have to see how it all plays out in the courts. The other case is under a different type of immigration proceeding, so it's not in the court, but it also deals with allegations of white-collar crime, We've dealt with a number of cases in recent years where there have been allegations of white-collar crime against clients in China, and this is a case of someone from China. The Ministers' Council submitted extensive evidence from the criminal investigation in China, including witness statements and various documents which originate a number of years ago, and that's relevant because the situation in China is alleged to have improved. I say alleged because it sort of depends who you ask. Some people will say it's actually gotten worse, and that's supported in a lot of the documents that we've presented. But certainly at this time there was a lack of protection for human rights in the criminal proceedings that were happening in China. China's human rights record is perhaps worse than the other country that I was talking about. I mean, there's notorious issues such as the Tiananmen Square massacre, the persecution of Falun Gong, and basically the evidence establishes that torture and mistreatment in order to extract confessions has been endemic in Chinese criminal proceedings, but especially in politically sensitive cases. And there's an additional layer of political intervention and oversight, as the Chinese Communist Party has a political legal committee that oversees and directs a lot of decisions in the Chinese criminal courts. So Ministers' Council also brought a witness in this case, an officer from the PSB, from the security apparatus in China, and this officer had been involved in the file, and he denied knowledge of notorious human rights abuses like Tiananmen and the Falun Gong abuses of Falun Gong practitioners. And in fact, some immigration practitioners will know that PSB officers have been determined to be inadmissible or excluded from refugee protection in Canada because of their knowledge or awareness of these things or participation in them. And yet this individual was offered as a witness against our client. And the Ministers' Council has argued that because China is an authoritarian country, it's not surprising that this individual wouldn't be entirely candid when discussing things like Tiananmen Square and Falun Gong issues, politically sensitive matters, yet we should still find him credible and trustworthy with respect to the criminal prosecution and his involvement against our client. It's hard to wrap our brains around that to some extent. There's an argument that things like Tiananmen Square and Falun Gong and other human rights abuses simply aren't relevant to our case, and we're in the process of responding to those arguments. So we have, serious concerns about the production of the evidence that we have reason to believe may have been obtained under torture, but also the production of a witness who denies notorious facts, and that Ministers' Council is still trying to assert that this person is credible and trustworthy. So these two cases and other cases that we've seen give us a lot of concern, and will hopefully provide some fodder for discussion and context for the more lofty discussion that will follow. Thank you. I really did cram it to 10 minutes.
Well, thank you, Tara, and it does indeed give us a nice addition to the shape that James was giving on the varieties of contexts in which these issues can arise. Our next speaker has a wonderful foundation and expertise in these areas. Barbara Jackman of Jackman, Nazami and Associates is one of our Canadian experts in immigration, refugee law. She has in more recent years developed a particular specialty in national security matters, arising in no small measure from her work, including her work with the Akabuchi and Arar inquiries, and we're delighted that Barbara Jackman was able to come today. Barbara.
My expertise in national security matters is only public national security matters. Anil has the secret evidence. I want to what I'm going to cover is the concern about not necessarily what constitutes torture, but what constitutes the kind of mistreatment that we should be concerned about in Canada, because there is growing evidence of mistreatment of particular persons, people who fit profiles. And secondly, the question of how responsibility for mistreatment is determined or will be determined by the courts. I don't have answers to a lot of this, but I think there are a lot of serious questions raised. I think the starting point is our self-image in Canada. We have a recent history that is strong on human rights, respect for human rights, and a long, long history of racism, both judicial and societal, in the past. And when you put that together today, when you come before a court, I think that we as Canadians, and our judges are no different than the rest of the Canadians, like to see ourselves as good people. You know, we don't intentionally harm people. And if it does happen, like the beatings that James is talking about, we're not going to call it torture, because we don't torture in Canada. That's the kind of attitude that you have, that you come up against, I think, when you go to court in Canada and allege that there has been mistreatment. I think it's a concern, because I do think in a democracy you don't improve unless you recognize that there are problems. And that's the strength of a democracy, is being able to speak about those problems and address them, and push the courts and society as a whole to address them. So in terms of torture, first of all, I think that in terms of what happens to people here more often, torture isn't the right word for it, because torture, at least in the Convention Against Torture, requires that there be an intentional infliction of harm, on pain or suffering, severe pain or suffering on the person, and that it be for a purpose of interrogating the person, to get information, punishing the person, intimidating or coercing, or for reason of discrimination. Now, in some of the cases, you could argue that it's discriminatory. That kind of definition really doesn't fit what happens. I mean, I think if you look at the mistreatment that Muslims have faced primarily since 9/11, that the Japanese faced in World War II, it wasn't a treatment intended to punish them. It was because we were afraid of them. They had been so dehumanized that they weren't seen as real people. And I think that's the real problem. People are being mistreated because we're afraid of them. It might be a lot of different reasons that the taunting that takes place in the jail is because they're not just afraid of them, they hate them because they believe them to be terrorists. So there's a combination of factors, but I think what happens often is really, it's a fear of what they might do, not what we have any evidence that they will do. Certainly with the Japanese that was true. And I think with some of the people who've been detained, like Hassan Omri, who was found not to be a security threat, and believe me, the standard is low to find someone to be a security threat. He spent more than 5 years in solitary confinement without shoes in a cold jail where the guards were wearing winter jackets at work because it was so cold, and he's in a t-shirt and no shoes. And that went on year after year, 3 years. We had to go to court to get shoes because they wouldn't give them to him, and to get jackets so that he was warmer in the jail during the wintertime. And then he wins his case and he's free. So was that treatment necessary for someone like Hassan Omri? But it wasn't like anyone was punishing him. They were afraid he might be a terrorist, and so these measures had to be put in place. He was detained October 2001. I think that it might be possible to argue that that kind of treatment is cruel, inhuman, or degrading treatment, but there's problems that arise as a result of that. Under the Convention Against Torture, torture itself is banned absolutely, whereas CIDT, the cruel, inhuman, or degrading treatment, is the states have undertaken an obligation to prevent it. So states do take the view sometimes that it may be justified to impose that kind of treatment on people. And then you get into the question of whether or not lawful mistreatment is, or treatment which is sanctioned by the law, is in fact, can be characterized as cruel or unusual when it's actually been approved of by Parliament or by a court. The jurisprudence that focuses on mistreatment, and I'm using mistreatment in a broader sense, not just in terms of torture, does cover both physical mistreatment as well as psychological. And I think in terms of the kinds of cases that we've handled, it's the psychological impact. And I'll give you an example. Like Hassan is probably the best example because he spent the 5.5 years in solitary. His world was, what time did he get his orange juice? When you reduce a person's life to the time that your orange juice arrives, and when they suffer an anxiety attack because it doesn't come when it's supposed to, you've done something to that person's mental ability to cope with their world. And that's the conditions that were imposed on him. It wasn't that, it was that the law permitted that to happen. That kind of mistreatment has been, where it has an effect, and it's intentional, has been recognized as torture, psychological torture, and has been in conjunction with other factors. Solitary confinement itself is recognized as at least cruel, inhuman, or degrading treatment. But when I raised the question about the lawfulness of that, in Sharkawi, we challenged in front of the Supreme Court of Canada Hassan's treatment. That was an issue. The two issues in Sharkawi was, should there be secret hearings? And the second issue was the Omre issue. Can you have persons put in detention without a bail review for an extended period of time, for an indefinite period of time? The evidence before the Supreme Court, 5.5 years in solitary, had to go to court to get shoes. I was getting emails from all around the world that they couldn't believe that Canada would put someone, they have this image of Canada as a really cold country. They couldn't believe Canada would keep someone in jail over the winter without shoes. Like from South Africa, I was getting emails when his case was publicized over the shoes. But in any event, that information was all before the Supreme Court of Canada. And what the Supreme Court said in dealing with it essentially was they recognized that the issue was raised. They didn't put in their reasons the fact that he had spent that time, or at least they didn't in the part of the reasons that I've reviewed, that he had spent that time in solitary. They just noted that the issue of cruel treatment had been raised before them. And they say they connect it with the indefiniteness of detention. And that was one of the issues, because we were saying, look, you don't know when his case is going to end. He doesn't know when he's going to get a detention review, a bail review in order to be released. So it has become indefinite because it's gone on for such a long period of time. So they addressed that issue, not the solitary confinement and the mistreatment while he was in solitary confinement and the effect of solitary confinement. And their answer was, it's not indefinite because we're going to give hearings. You're going to have hearings every 6 months. It's only fair. You have to have a review of the need to be detained. So from henceforward, the law will be that it's not indefinite. But that ignores the fact that he's already spent 5.5 years in solitary confinement. Like, what do you do with that? If the Supreme Court, they don't say it's not cruel, and so I think they've left the door open for him to argue that it is, but they also don't deal with the issue at all, and it was raised foursquare in front of them. So by not dealing with the issue, are they saying this is okay, or we don't really want to deal with this because it's problematic for us? Let's deal with the easier issue. Let's get him out of jail so that we don't have to worry and we can paper over what happened in the past. But in effect, that's a really bad starting point for anybody who wants to argue that the kind of conditions that they've lived under for a period of time because of loss like this is cruel treatment. If Hassan couldn't win it after 5.5 years solitary, who can on the issue of cruel treatment? It's problematic from that point of view. The other thing is that for the security certificate detainees, after they got out of jail, and some of them were 6 or 7 years in jail before they were released, they were subject to stringent conditions. And I don't know if you read, I don't know if it was covered in the paper, but I certainly got it on email, that Mr. Majoob's conditions have been relaxed. Mr. Majoob has been on GPS bracelet since he was released in 2007. And he's had cameras watching him go in and out. He's had, for a long period of time, he couldn't go out of his house without a supervisor. I'm running out of time and I haven't even covered any of these. In any event, those conditions were imposed by a court. And the court just took them away in his case. Mr. Jabala still remains on a GPS bracelet. When you couple the conditions that that have been imposed on the men after they were released with the lengthy period of time that they were detained and the impact it's had on them, and the impact that the conditions have had on their families. Mr. Jabala, for example, his children have all suffered psychosomatic illnesses. That's evidence that's been brought before the court. They're not before the court, but how much do you take into consideration their situation when a court is imposing conditions? Those are all lawfully imposed conditions, and it raises the question of whether or not that makes it all right. Is it all right if a court has approved the conditions, but the effect on the person is to psychologically damage them and their children? Does that make it cruel, or is it not cruel because a court said it's okay? So like I said, I raise more questions than I answer. We certainly argued to the court that those conditions at some point become cruel the longer they remain. But you can't turn to any official and say, you're breaching his human rights, when a court has authorized the official to do what they're doing, including following them around all over the city. The federal court authorized that as well. If it's combined with lawful and unlawful, can you then raise it as cruel and inhuman treatment? I think the big problem we have, really, and I have to close, is recognizing that some of these conditions may be, or some of the ways that we treat people may be inappropriate, and confronting that as to what the real reason is that we're imposing them, and then recognizing that they haven't been treated fairly in the process. Those are my comments.
Our final speaker in the first part of this session is Anil Kapoor, a criminal lawyer, experienced criminal lawyer here in Toronto, and also an appointed special advocate authorized to conduct national security litigation. He has extensive experience both in the criminal sphere and in the national security sphere. He was commissioned counsel to the Air India Public Inquiry, and so Anil is really the perfect person to sort of round out our initial comments. And then we'll have a chance for some conversation within the panel and out to you. So Anil, please.
Thanks, Ben. I want to start a little bit by contextualizing why these terrible things that you've heard the other panelists have talked about, why they happen, and arguably why they will continue to happen. And in a case called A and Others at the House of Lords, Lord Hope wrote, in deciding whether there's evidence of torture or not, he had this admonition to all of us. He said, too often we have seen how the lives of innocent victims and their families are torn apart by terrorist outrages. Our revulsion against torture and the wish which we all share to be seen to abhor it must not be allowed to create insuperable barriers for those who are doing their best to protect us. A balance must be struck between what we would like to achieve and what can actually be achieved in the real world in which we all live. That sentiment is behind all of these cases. That's really what's going on. And where our tolerance for infringements on our civil liberties is directly related to what kind of victim you perceive yourself to be. Are you likely a victim of a terrorist attack? Or are you likely a victim of state excess or police excess? And when you locate yourself on that continuum, you will define your tolerance for incursions on civil liberties. The problem is, for people who care about civil liberties, the problem is that our courts typically don't approach the problem that way. Policymakers typically do not approach the problem that way. So they don't they don't put in systems in place to correct for those kinds of biases. But the first step, I think, is to identify the bias. Identify where you're weak so that you can compensate to have a strong system. But I think few would say that we should not ensure our national security. And few would say that there isn't a necessary imperative on the part of the state to ensure that we're all safe. Those principles, I think everyone signs on to. But the execution of those principles is what matters. And so, for example, and I know this may encroach on the following panel's mandate, but I just want to give you a little sort of line of how this can end up in a courtroom. You're a CSIS officer. You're sitting in some foreign country. You're a liaison person. You meet with your counterpart opposite, and they tell you something about Anil Kapoor. Anil Kapoor is A, B, and C equals bad guy terrorist. You should know this, Bob, because he's in your country. At least that's what we have. We think he's in your country. Bob telexes back. They do some inquiries, and they discover Anil Kapoor is in the country, in Canada. And they've got some information that he's a bad guy. So if you stop right there, would you say, do nothing? Would you say, investigate some more? Well, probably you all would say, investigate some more. I doubt anyone would say, do nothing. So if you add a fact in that the country in which the person is at is a country that's notorious for human rights violations, would you say, do nothing? Would you say, investigate some more? You'd probably say, investigate some more. And what would that investigation be? Well, what's Kapoor doing? The focus is on the person who's the target of the investigation. And that's what the agencies do. That's what police forces do. The focus is not so much on the partner who gave information. The focus is not so much on their fidelity to principles of human rights. Because from an operational perspective, the first question that's asked is, how can we be safe? Not, how do we protect human rights? And I want to suggest that that's probably not the worst case scenario, unless you're doing the torturing yourself as an agency. But getting information and trying to secure the population is probably not a bad mandate. But where it becomes problematic is when the operational norm is ported into the legal system. When you take intelligence agencies' practices and you seek to convert them into normative legal rules, you abandon a commitment to human rights, you abandon our constitutional democracy, and instead what you do is you cede the drawing of the balance to a partisan. You cede the drawing of the balance to the agency that's charged with the responsibility of ensuring security. And that's just not the rule of law. Why? Because the agencies, despite their protestations, do not really execute the rule of law. What they do is comply with their statutory mandates. Different things. Totally different things. And if they do demonstrate fidelity to the rule of law, then there's nothing for them to fear. Then judges will sign on, everyone will be happy, there won't be abuses. But if they don't, where do we go? To whom do we ask? We ask our courts. We ask our judges to be independent. If you accept operational norms as the foundation for legal rules, you cede independence. You cede judicial independence. And when that starts to happen, then we've got a real problem. A real problem. And when you go back to what Lord Hope had to say, A balance must be struck between what we would like to achieve and what can actually be achieved in the real world in which we all live. That means the real world where there's respect for human rights as well as security. They're not inconsistent. It's not a zero-sum game. Value choices have to be made. So I would ask all of you who are involved in this work to keep in mind biases you may harbor. Recognize that there is a legitimate state interest in ensuring security, and I underline the word legitimate. And also expend some of your energy to fund the efforts to ensure independence on the part of the judiciary. And that can only happen by the quality of arguments that we make, by the quality of judges that we appoint, and by the statutory framework that all of us as policymakers, through our representatives, seek to have passed in our legislatures. Only then can we have a balance that I say is more fair and respectful of individual dignity. Thank you.
Thank you, Anil. So what I'd like to do now is, as you queue up at the microphones, I just want to put a couple of comments on the table for our panelists to respond to, or to respond to points that might have come up in each other's presentations. And we'll have people coming up to the microphones, and we'll turn it over to an open conversation. So just a couple of things that I wanted to note arising out of these presentations. One point I'd be interested to hear from any of you on is has to do with the role of constitutional norms, and specifically the Charter in what you've discussed. It's an interesting feature of the conversation thus far, talking about evidence of torture in courts in Canada, that the Charter figured extremely marginally in our presentations thus far. Barbara raised a little bit norms about cruel and unusual punishment, but in the other conversations, it seems that those rules, norms, principles to which you each returned had little to do specifically with provisions of the Charter or adjudication with the Charter in hand, and much more to do with subsisting norms of a kind of more fundamental nature. And so, you know, a question is how influential the Charter has actually been in putting us in a safer position with respect to torture, with respect to mistreatment or unfair treatment in each of the contexts that you've described. Of course, on the other end of that is the idea of whether the existence of the Charter, if it's not doing those sorts of things, is serving a pacification role. That people feel as though with the Charter it must be the case that these things are somehow stopped, even though it seems that they actually have a relatively marginal role in the day-to-day operation. The second point I just kind of wanted to draw out, and then I'll turn it to our panel and then open to the audience, is an interesting tension I think that came up in the conversations about what gets called torture and what shouldn't be called torture. And I think there's a productive tension there, in a sense, between what James and Barb described as different routes that you might take. On the one hand, the argument might be to leverage the abhorrence generated by the language of torture to capture the variety of practices that can plausibly be called torture, and that there's a strategic advantage to doing that. On the other hand, it might be that the argument is to privilege or restrain the use of the language of torture and to categorize differently the various kinds of mistreatment and unfair practice from the government in different kinds of terms, preserving that language in a certain way. And so that classic kind of conceptual question of how broadly do we approach this, how narrowly do we approach this, something that touches on the conference as a whole is something I wanted to raise. So just before turning to the audience, I wonder if there are any remarks either in reaction to each other's comments or to these other points from the panel. James?
Well, I think the two questions you pose are very much interrelated. I think that no one would say, no authority on the Charter would say that the Charter permits torture. And I think courts would if confronted with the question, would readily concede and acknowledge that if the Charter forbids anything, it forbids torture. The challenge becomes the one of labeling and this resistance, this cultural and sort of institutional resistance that we have in this country to label state abuses that cross the threshold of the legal definition of torture. And by resisting that, we don't have to make any comments or statements about what the Charter permits or forbids in this context. So what's really interesting about the two cases I talked about, Tran and the other one that I'm involved in neither case does anyone say the word torture, ever. It's not in the Tran judgment, it's not in the trial judge's judgment in the case I have under appeal.
And should they be?
Well, I hope they will be. That was part of my, that's part of my argument that, of course, when you measure up the significance and the seriousness of what the state has done in these cases, something that you have to be cognizant of is it's torture, and not only does it violate domestic law, it violates Canada's international human rights commitments. And I think that sort of leverages up what's at stake here. And that's what I, as an advocate in that context, have to do to try to convince the court this is one of the clearest of cases that warrants a stay.
Okay.
I think one of the problems why our domestic jurisprudence doesn't use that kind of language is because, at least in the criminal law, criminal lawyers typically do not turn to international law to make their submissions. There is a rich environment in the international law that sort of defines and sort of talks about what is torture and what isn't torture. And there are cases, ECHR and other ICJ courts where they found torture to exist, or a CIDT. So some of it is counsel not going there, and certainly our courts naturally don't go there. So I think that's part of the reason why you don't see it as part of our legal vernacular.
And I think in our area of law, in immigration, it's accepted that it would be a charter breach, but in Suresh, the issue was, do you send someone back to face torture? They recognized Suresh might be tortured if he was sent back. So ever since Suresh, of course, the department decides, the Canadian Border Services Agency decides no one's at risk of torture. And so the issue becomes factual. Is he at risk of torture? Is he not? And largely it comes down to, you can never, you don't have the predictability that you might have had in Suresh's case where, the Sri Lankan High Commission was issuing press releases through the whole case. You knew darn well they were watching the guy. They made no bones about it. They characterized him as a big fish. You don't have that in most cases. It's a judgment call as to what you think will happen. And I'll tell you, with the Tamils right now, we have had several people returned who have been tortured after they've gotten back. And we've been raising that issue now before the courts about whether or not Tamils who are because it's happening to Tamils being returned from England and returned from Australia, it's happening to Tamils who've been returned even a couple of years ago, that they're now being detained and tortured. And the trying to, again, when we're in front of the judges, it's a question of having them believe that might happen to the person that's in front of them. There's a reluctance, understandably, an unwillingness to recognize or to want to recognize that that someone might be harmed as a result of a refusal to let them stay in Canada. So they're hard issues, but it becomes facts, not charter.
Any other comments from members of the panel before we turn out to the audience and get the broader conversation?
I just had one response to I think Anil's very interesting comments, in that in the context of the cases that I was talking about, we're talking about white-collar crime, which is still obviously a serious issue and one that we have a national interest in not harboring criminals, but I personally look at it in a different light than the risk of having someone local commit a terrorist act in Canada. And I think that spectrum maybe has to be taken into account when we talk about that as well, in my opinion anyways.
Great. Well, I know that there's a few people that have at least shown an interest in asking a question, and please, we'll start on the left side of the room and stage left. Your right. Please,
Thank you,
go ahead.
Benjamin. Professor Amir Ataran from the University of Ottawa. 3 rapid-fire questions. James, concerning the reluctance, the reticence to use the T word, and to indeed prosecute. Section 269.1 has not been used. I've looked at it too. Yeah. Question, is it possibly worthwhile to commence a private prosecution under that section, knowing that, of course, it will be stayed?
Immediately.
But you force them to go through the exercise of intervening and staying it, and that does get their hands dirty with it. So is that worth doing? Barb, on the issue of security certificates, good to see you again, by the way. On the issue of security certificates, obviously the Charter has been a bitter disappointment, really hasn't done much for those people. Would it have been better to use habeas corpus? I always, when I read habeas cases, I notice the hagiographic terms, that the language is completely different from Charter cases. Would it be better to use a common law approach of habeas? Anil, last question and the hardest. I think your two observations about how one feels about these cases depends where one sits on the continuum of being more likely a victim of state excess or a victim of terrorism. Brilliant observation. I couldn't agree with you more. You also said that states, agencies tend to abide by their statutory mandates rather than the broader rule of law. Again, I agree with you. But here's the question. You ended by saying it will take reform to our statutory framework to change this. So my question for you is, what reform? What would you change if you were king for a day?
So I guess I'll start. It's funny because Ben and I were chatting right before the session about this very question. We were querying whether this is one of those provisions that requires the approval of the Attorney General before charges can be laid, and it isn't, unlike treason, I think is. And so, people have tried this kind of thing, not with torture, but as a route to holding state officials accountable. I know that Julian Faulkner has done this with some success, at least in terms of shining a spotlight. But I think those amendments, those recent amendments to the provisions, the privately laid information provisions that essentially allow the government to intervene at the inquiry stage before the justice, before process is even issued, and essentially stop it, are going to be an impediment. But I'll let you follow up. You have another question or comment?
Very quickly on that, I actually query the constitutionality of those, because this is more detailed than you probably want to know. At Confederation, private prosecutions were the norm.
Yeah.
Right? In 1867, it was normal to do private prosecution. Regina or Rex hadn't stepped up to the job yet. That only happened later, and it was, I believe, around 1910 that the balance shifted. Question, could one argue that taking away the power of a court to hear a private prosecution offends Section 96 of the Constitution, because it's part of the inherent power of a superior court? So could you actually go after Constitution?
I think, listen, it's an interesting argument. The challenge is, I think, today, I know that those recent amendments were recently interpreted by the Ontario Court of Appeal in a way that gives the Crown even more authority than I think on their plain reading is warranted. So there's not a culture that's going to be receptive. I think the courts are happy to see private prosecutions come to their end. Yeah, they're seen as a nuisance. But I hear you. I mean, you wonder, the SIU could charge torture in some of the cases, and it never does. Why couldn't a private individual do it?
Barb.
We tried for years to get around the federal court process and use habeas. We lost, ultimately. We lost in Race in the Supreme Court of Canada. We lost Baroud directly on the detention issue in habeas before the Ontario Court of Appeal. I remember Justice Carty saying, look, we gave you Race and we got overturned by the Supreme Court. We're not going to give you Baroud. So we lost the habeas issue in terms of being able to do a direct habeas application. I think that I can't say we've gone back to look at the case law around it to see if we can analogize in our cases before the federal court, but it's not a bad idea. But we can't bring habeas. The door's closed. Well, every time I go to the Ontario court, it's on a habeas application. So the few times that we have, there's one little exception, and that little exception is where the federal court has failed to give a remedy that it needs to give. And the Ontario court judges will give an injunction so that you can preserve your remedy in the federal court. That's the Suresh case. That's as far as it goes.
So thank you, and I've taken the view that the habeas remains available in federal courts in idiosyncratic sort of reading, maybe.
It's
But I think
available, it's not used.
Yeah.
And if you try to use it, they just shut you down. That's the problem.
Anil.
Well, I don't know that there's one particular thing there, it's all of a piece, but as far as statutory reforms are concerned, I think that one of the things that should happen, at least in security certificate cases, is there needs to be a reconsideration of admissibility rules. I'm not saying necessarily that you bring in the entirety of the normal criminal law admissibility or rules of evidence, but we presently have a standard which is reliable and appropriate, which is essentially, in my view, sort of meaningless. And when you look at the public record in these cases, like newspaper articles get filed. I mean, no disrespect to the fourth and fifth estates, but you know, Colin Freese is a great journalist, but you know, his newspaper articles may not necessarily be the best basis upon which to decide a case. Sorry, Colin. So you know, there's just really, it's a sort of meaningless standard. And I think one way to ensure greater protection is to have some evidentiary reform of how, of the kinds of pieces of information that judges should rely upon. Turning to their better angels doesn't necessarily always succeed, as obscure as they are.
Thank you, the panelists. Thank you, Amir. Other questions? François, and we'll come over to the right.
It's just an invitation to the panel. We've talked about the criminal dimension and the immigration dimension. I wonder whether you could give us some comments about the civil landscape, right? Suits for compensation for torture. Of course, there's the issue of state immunity that always gets in the way, but we have a new act now that allows to sue certain states, Iran and Syria, for terrorist activities. But then we have the Jacobucci inquiry where we say internally, well, we ought to compensate certain people. The government just doesn't do it. The Committee Against Torture needs to come out and say, do it, and still there's no action. So what's your sense of what's possible in that realm? And a question appended to this, well, torture often comes with the question of national security. We have a system to deal with national security, so-called classified information in the immigration and the criminal context. What about the civil context, right? Information that comes from abroad, you know, may be subject to torture, yet there's really no system. We don't have special advocates there. So how do we, what do we do there?
I'm acting on the.
Barb, please.
I'm acting on several of the civil actions for Canadians that were tortured abroad, and I'm not acting as the principal counsel. I'm just helping the civil counsel. But in those cases, they're mired down in an argument about what documents are going to be disclosed, and so I think their statements of claim were filed in 2004. They agreed to put the cases off while Arar finished and then Jacobucci finished, and on the understanding that the government would enter into good faith discussions around settling the cases when Jacobucci finished with his commission. And then, of course, there were no negotiations. The government changed. There was no good faith negotiations. And we've been involved for the last 3 or 4 years waiting for documents. It's being monitored by 2 courts, the federal court and the Ontario court, around the document production. And there's all sorts of complicated issues about which court, in the end of the day, gets to decide the final decision on what's public and what's not. Federal court has the first kick at the can, but there's an open question of whether the Ontario court does. But you know, the reality is that it's an illusory remedy when it drags out for such a long period of time. It not only is it illusory, it compounds the injustice that the person's already suffered, because it is just so painful. I mean, the Jacobucci inquiry, secret as it was, people don't realize that kind of stuff. Like, that was a slap in the face to our clients. They didn't know what was going on the entire time, and that's as aggravating to them on top of the past torture that they've experienced. I just remember going through that with them, and it was just really hard. Like, I found it painful that they didn't know what was happening, and it's hard to explain it to you just how Kafkaesque that is, that process. So nothing has been done right in those cases, and I don't know whether those men will ever see justice. It's just an ongoing struggle.
Briefly, and then, sir, you're the next up.
On this issue of civil claims, there is, in the UK, of course, legislation, at least I don't know that it's passed yet, that would allow for material proceedings enclosed in civil cases. And here's the thing. You can have an intelligence agency that in good faith acts upon information and to the civil standard discharges all the duties of care, all right? But it turns out that the information was abstracted by torture, let's say, and the person was returned over or information was given on the strength of that, which resulted in one of Barb's clients being tortured, or not these ones particularly, but some others, let's say. But the civil agency, the civilian intelligence agency has a complete civil defense, right? Because they exercised due care, they discharged their standard of care, and they say, hey, it's not me, we did everything properly. The problem is that much of doing everything properly resides in closed information and in secret information. So the agency's in a situation where the agency says, do I release the information? If I release the information to defend it, then I might be compromising some intelligence value or intelligence relationships. If I don't release the information, the plaintiff is going to get a windfall. Okay? And so the British have approached this by saying, they have in the statute that's I think on the order paper, I don't think it's passed yet, for closed material proceedings, CMP. And those proceedings will be the analog to what you see in the security certificate cases. Now, I'm not suggesting that that's what should happen, but that's a real policy problem that I think is occupying the big brains over in Parliament about how to manage civil litigation when your defense may reside in closed information.
But do you really think after this many years of doing these kinds of cases, and I'll tell you this secret stuff has been going on since I got called to the bar in the late 70s. I mean, my first clients were Chileans where they didn't know the evidence against them. I don't believe it's necessary to have secret evidence. I really don't. I think they could ask third-party states, like other states, for permission to release. They are all protecting each other. That's what it is. It's states protecting each other, saying, well, I can't give it to you because Egypt won't let me, or the United States won't let me, and the United States says, I can't give it to you because Canada won't let me. It's just a big game.
Or alternatively, you say, look, you don't take the legal system and pervert it by having closed civil proceedings. What you say instead is, if you want to claim privilege, the tariff is pay the damage.
Yeah, that's it, because then they work harder at disclosing it. Right. But there are so many cases where in one proceeding we get disclosure and then we're in court and we don't get disclosure on the same issue. I just did a case in front of the Court of Appeal where they said if it's already public, you can talk about it. They talked about something that was secret in their reasons in the Federal Court of Appeal. That's Southroy. Never made public. Court of Appeal talks about it. I mean, it was made public in another proceeding. Secret in the proceeding before the court. They talk about it publicly with no one questioning whether or not it can be made public. Like, it's a game. A lot of it's just a game.
Well, thank you. The civil proceeding question also drawing out this important dimension of the secrecy or non-secrecy of the evidence, and I'm sure that's going to carry in through the other sessions as well. Please.
It's Walter Dorn from the Canadian Forces College. I'd like to address my question to James and Barbara, using your first names, if I may. In the case of the police who had done the beatings, and the case of the decision makers who had confined Hassan Almari to 5 years of solitary, what kind of repercussions came to them, and what kind of means are there to make sure that those who make those kind of decisions are held accountable?
Just talking about the two cases that I made reference to, in Tran, one of the factors that the Court of Appeal made reference to in finding that the violation was especially serious is there was no information that anything had been done to the officers involved. And I think subsequently it was referred to the SIU. I don't know whether charges have been laid. And in the case I made reference to date, charges have not been laid, although I know that the SIU is aware of it. I'm not sure why. Obviously, that's within their discretion. Maybe they're waiting on the outcome of the legal proceedings. Who knows?
With my clients, nothing happened to anybody. They were following policy. That was their, the whole thing about the shoes was that it was policy not to let them wear shoes. It just wasn't policy to have people held for 5 years there. most people were in and out of solitary in a fairly short period of time. And the fact that he was in solitary, they said ultimately, after having told everyone he was a terrorist, they said it was for his own protection. So that's why he stayed in, because he would have been attacked by others because he'd already been identified by the guards as a terrorist. So nothing happened to anyone.
Other questions? Please.
So I'm not sure if you guys have talked about the movie Zero Dark 30 yet. That's coming out soon. So I just recently read an article about it, and then, you mentioned how film and cultural depictions of CIA, like intelligence agencies, shape everything. And you're mentioning kind of secrecy of the evidence, but I'm thinking about secrecy of actually getting the evidence, because the movie seems to indicate, like, they kind of go over the top a little bit, but the movie seems to indicate that the slapping or the waterboarding was necessary to gain information about how to find Osama bin Laden. So, to what extent, what do you guys think about that? The Osama bin Laden thing itself, but also the film depiction of it. Do you think that that's positive, that we should be making these kinds of movies, making people more aware, or do you think that that's going to detract from their ability to, find terrorists?
I didn't see the movie.
Any comments? I don't know, some have seen the movie.
I don't think any of us see the marks. You've seen it?
In a sense, Anil, the question raises the differing logics, the two different logics that you brought out, which was the one concern about intelligence and the other concern about rule of law.
Yeah. Well, the movie's the movie. Whether it should be made or not made, of course it should be made. If somebody wants to make a movie like that, they can go ahead and make the movie. I don't see any reason why the movie can't be made. The one salutary thing about the movie, though, is that it does spark a conversation about it. In the Washington Post, I think last week, there was a discussion. One of the fellows that certainly defended the legal memos wrote a piece about how the movie doesn't get it exactly correct. The waterboarding wasn't integral to getting the information, but you can all look it up on the Washington Post. But it's just a discussion that happens again. I don't think it hinders or it assists in national security or human rights protection.
We have a bit of time for other questions. Thank you, please.
Why not?
Absolutely.
So my name is Stephanie Silverman. I'm a postdoctoral fellow here at the center. I just had a quick question about documentation of torture, mostly to do with immigrants and refugees. In the UK, they have an issue now where there's not enough doctors who have access to detention centers to document the torture that refugees suffered in their countries of origin. And so the few doctors that do have access have been discredited by the state. And so now lawyers are now faced with the question of whether they bring in these doctors who can document medically the torture, but possibly discredit the evidence, or whether they just want to sort of have an ad hoc description without the medical advice. So I'm just wondering more about how you see the Canadian system dealing with the medical documentation of torture and whether that's an issue here, especially as it regards the possibility for refoulement. Thank you.
Why were they discredited? Because they did reports on torture victims?
Because they're seen as activist doctors.
That's what I thought. So it's not really a discrediting, it's
There
because
have
they're
been
activists.
sort of smear campaigns, I guess, in the UK against certain organizations that do provide doctors and nurses to detention centers. So speaking with lawyers, they are now faced with this kind of moral dilemma over whether they invite the doctors into the courtroom or use their dossiers at all because of this discredit and reputation that the organizations have received.
Well, here we have the CCVT, the Canadian Centre for Victims of Torture, and it has a roster of doctors, and not just doctors, regular doctors, but psychiatrists and social workers and therapists, people who can assist refugees in help because they're torture victims, but also to do reports for their claims. So, and there are doctors that do it, that do these kinds of reports. They're sympathetic to victims of human rights violations. I don't think that makes them biased, but so we don't have the same kind of problem here. I mean, I know that there are officers that will challenge a psychologist's report because that psychologist has done other reports, but so far it hasn't really been an issue here. So yeah, we do try to document to the extent that we can. My general preference is to send people, by the way, if anyone's going to be doing this kind of work, is to send people to psychologists. They write better reports than psychiatrists. I think.
Please. There's a microphone right behind you, too.
Quick question, not quick question, quick comment on that last comment. I'm Teresa Dremetsikas from the Center for Victims of Torture, and I don't agree that psychologists do it better than psychiatrists.
I just meant they're more wordy in their reports.
I disagree. That's all.
I think you just lost a report, Barb.
No, it's true. It's true. There's good psychiatrists. It was just the degree of detail. I found the psychologists were more wordy than the psychiatrists, which is always helpful.
Craig, please.
Yeah, Craig Scott, professor on leave from Osgoode. I just wanted to add a point to the range of scenarios and contexts that were covered, just almost for fulsomeness. We might not get to it on our panel. It's important to know that when we're talking about the Charter, and we're talking about this kind of imagery of torture as something that occurs abroad, and then the third element of, we don't do it. Everybody should know about the Federal Court of Appeal case and Amnesty International against Department of Defense that basically has ruled that the Charter did not apply to the context of transferring Afghan detainees in Afghanistan by Canadian agents, soldiers, troops, whatever, to Afghan authorities where there's a potential aiding and abetting nexus. So there actually would be a torture-related crime there, but for Charter purposes, Federal Court of Appeal ruled no go, but lacing in a bunch of comments that might suggest that if by chance the people who had been transferred by Canadians had also been Canadians, they might have found a way to somehow have the Charter apply. An appallingly reasoned judgment that for which leave to appeal was denied by 3 judges on the Supreme Court of Canada, and that's where we're at right now. So we have to keep in mind the whole question of how the courts are dealing with responsibility in other contexts. It just so happens Afghanistan is the biggest example at the moment where we might potentially be involved. Well,
the most fruitful area of research to support a private prosecution or whatever is the complicity case law in the federal court. They found everyone complicit from other countries who are making refugee claims. So anybody where the state alleges that someone was, in fact, this is the case that's before the Supreme Court right now. I'm sure you're aware of it, Craig, the Zakola case, where the guy was a diplomat in a foreign mission somewhere, and he was held to be a war criminal because of what his government was doing. That's a very broad concept of complicity. But if you want to use it against Canadians that have been involved in torture, it's probably very helpful. I just don't think they'll apply it when you're talking about a Canadian.
We have about 4 minutes left and at least one more question. I just want to see if there's anyone else as well. This is kind of the waning window for our first forum, but of course 3 more sessions to come. And in the meantime, please, Amir.
Okay. I just wanted to throw a few ideas on the table to do with accountability after the fact, civil accountability, Barb. One of them is this. In the UK, under the Human Rights Act, a remedy for a violation can be for the court to order an inquiry. Here we sit around begging, oh, please, give us an inquiry. And then it turns out to be Yakabuchi, which was it would be vulgar, I won't say it. We ask. In the UK, they don't ask. Once you establish the violation of the right, the court can order it. There will be an inquiry, and that inquiry even had, in one instance, the Bahamusa inquiry, the power to set damages. It was extraordinary. Now, that could be a Section 24 charter remedy for us. Could a court order an inquiry? But I don't know of that being tried. The other idea I wanted to throw on the table is this. We do have this new carve-out for Iran and Syria that they can be liable despite the State Immunity Act. Here's an interesting question. The Iran and Syria carve-out was carried out by order in council. It was an order in council under the Act that said, Iran, bad, Syria, bad, and took away their state immunity. Could one challenge that order in council under Section 15 of the Charter as being under-inclusive? Discrimination on the basis of national origin. If you're Iranian or Syrian, then there's a carve-out for you to state immunity if you're a victim of torture. But if you're from some other country and you're a victim of torture, there isn't such a carve-out. An order in council is subject to the Charter, after all.
Thank you. Any comments on that or other questions from the group? I might ask before just closing the panel for any final comments that the panelists would like to make. And then I know that our convener, François Tanguay-Renaud, who's done a great job and a tremendous amount of work pulling together this forum, has a few okay, well, let's thank him now. And I know he has a few words of instruction before our break, but any final comments from our panelists?
Well, I just think it's really important that we have these kind of discussions because we're all in our own spheres working in one way or another on the issues. And so, some of the suggestions you've made, Amir, are helpful. And but it also think maybe there should be a listserv where people can sort of keep in touch in terms of developing it because there really is a lot going on. And the issues are just so important. I think I'm probably hypersensitive because I do so much refugee work from different countries where you see that the rule of law doesn't apply, the courts are corrupt, and nothing's done in terms of accountability. And I probably am overly sensitive to worrying about whether or not that will happen here. And it will if we don't ensure that it doesn't, right?
On the point of accountability, I don't want anybody to think that civil suits are going to be of any use to anybody, certainly not any Canadian that's been the victim of police excess. You just have to read Ward, and it'll tell you, what did he get, $5,000 for essentially a strip search and rights violations. So our courts have essentially, I think, made it virtually impossible for there to be any effective civil redress for charter violations by police. There's just no money in it. And, unless you have a guardian angel that's going to run the case for free, you're just going to be out of luck.
Thank you, Anil. Tara, James? No? Well, I hope you'll join me in thanking this great panel before we turn it over to François. Please join me in thanking Anil, Barb, Tara.
I don't have much to say. The only thing I want to say is that we'll reconvene at 2:30 sharp for a second panel on evidence of torture and executive action, the CSIS, RCMP, and CBSA issues, with also an American perspective. And Barb, I want to echo your comments. I think it's important that we talk, and I'm glad this is happening in a university. It should happen here.
Yeah.
Appreciate it.